Morning. Please be seated. This is the time set for oral argument in Stouffer against Premier. Our cause number 1CA CV150026. Counsel, I'm sure you are aware that we've read the briefs, we know the case, we've conferenced the case, and you can bear that in mind as you make your presentations. We are being audio and video recorded today for dissemination on YouTube, so please announce your name and that of the party you represent when you approach the podium. Each side has 20 minutes for oral argument, and the appellant may reserve as much time as you wish, subject to the requirement that you watch your own clock. And with that, you can begin. Go ahead.
May it please the Court. Good morning. My name is Ronald E. Warnicke. I'm the attorney for Carl and Fabiana Stouffer, not Stouffer. Not important to you or me, Your Honor, but Mr. and Mrs. Stouffer correct me constantly because I misstate it sometimes. Let me begin just briefly. Again, I don't want to get into the minutiae of the briefing, but I do want to ask the Court to remember that this is a case under ARS 33420, which is a statute which says if false documents are recorded, one can sue and do two things: remove them from the cloud on the title and to obtain damages. But it also provides for exemplary damages, $5,000 just right off the bat without proving any actual damages, and for attorney fees. Now here we've had an argument because of the Sitton case over materiality, as though there has to be some serious injury. But I would like to ask the Court to consider that in the Stouffer case we didn't get there probably because, unlike Sitton, which was a completed sale and a summary judgment and a note holder who wound up owning the property that was secured by the deed of trust, here we have documents purporting to sell the property in the name of someone who, Premier Mortgage Services, that does not own the property. These are false documents. They go nowhere, and they should be taken off the title. And I believe, Your Honor, that the Court in Stouffer, and I know you, Judge Swan, were on that panel, said that we could clear title to those documents. Now we have an appeal.
Well, I don't think the case said exactly that. The case remanded for further development. The case did not conclude that any misrepresentations were material or anything like that.
Well, Your Honor, I thought that if we proved the allegations of our complaint, that we were entitled to clear title of the documents that were being foreclosed in the name of an entity that did not own the note. But perhaps I'm mistaken. I don't think we have to go there, Your Honor. I'm not. All right, I'm not trying to play a gotcha on what Stouffer said. I'm just trying to lay the groundwork here that whether the Stouffer opinion said that or not, it makes sense. These documents are for a dead sale. It's been canceled. But these documents are still there, and they were there then. And under ARS 33420, the Stauffers were entitled to have them removed. Putting that to one side, I want to call the Court's attention to the fact that nowhere in this case is there an allegation of a default by the Stauffers, and this is a motion to dismiss. More importantly,
I'm sorry, nowhere in this case is there an allegation of default?
That's correct, Your Honor. Zero, no place in the complaint. I drafted it. I was very careful 4 years ago. I've read it half a dozen times since then. There is no allegation.
The Court of Appeals opinion in the same dispute that identifies the default.
That, Your Honor, the Court of Appeals said that.
Can't be blind to that. There was a default.
It wasn't material, we didn't think at the time.
The default wasn't material?
No. Whether or not there was default was not thought to be material, because if there had been a default, it would have not been in favor of Premier Services or against Premier Services because it didn't own the mortgage. It didn't own the deed of trust. And we had no oral argument in that case, Your Honor. And I didn't have the opportunity to correct it. But trust me, read the complaint. There's no allegation of default.
Are you representing to this Court here today that there was no default?
Well, let's talk about that. That was my next point. And then
Very simple.
Then I will try and.
Did your clients make the payments or not?
There is no definition of default, paragraphs A through R of the deed of trust. There's no definition of default.
I asked you a very simple yes or no question.
There was a delinquency, Your Honor.
Was the delinquency cured?
The delinquency was solicited after a barrage, many, many months of, we can help you, we can help you, we want to help you.
I was also on the Steinberger panel. I'm familiar with that fact pattern as well, but was the delinquency cured?
There was a delinquency. It was not cured, Your Honor. But that is not a default, as has been said. If you look at the note, which does talk about a default, it requires that a notice of default, capital N, is required to be served by the note holder. Not by the beneficiary, not by the lender, but by, or its nominee, but by the note holder. And in this case, the note holder was not Premier Services Mortgage, which was the person on whose behalf the deed of trust sale was being held. And that's another big difference between Sitton and the Stauffer case. In Sitton, we had...
Let me just get the facts straight here. The payments weren't made, and there was no deficiency liability. Are those two statements correct?
I'm not entirely sure about the deficiency liability, Your Honor. That statute has changed several times.
Did your clients face deficiency? Did your clients face a deficiency judgment?
I honestly don't know.
Okay. Well, I mean, it would seem to me that if you're going to argue Sitton, and you're going to argue footnote 6 of Sitton, which I know has been a point of discussion, that's something you'd want to know. Because if the payments weren't made and there's no deficiency liability, it's difficult for me to see the path to materiality.
Well, we have a liability on a second deed of trust. And I want to get to that in a moment.
Was that a purchase money second deed of trust, or was
It was not a purchase money.
So it was not subject to the anti-deficiency statute.
Exactly. That's
okay.
my understanding. And that's a big problem.
No,
that's why we never got there.
That's a helpful clarification.
And now, of course, they're saying, well, that's no longer material because that's been released. Well, I don't want to get pat outside the record as to why that had to be done. But the fact that it was there, and what do? Here they have a sale being conducted on behalf of someone who we know doesn't own the note. We know that because, despite Hogan, we have the note. It was delivered to our client, and it was assigned from Premier to Ohio Savings Bank. Ohio Savings Bank, as I think the court knows if it looks at the take judicial notice, and this was in the earlier opinion argued, taken over by the FDIC. We don't even know whether Ohio Savings Bank owns this, whether the FDIC still owns it, whether it was sold to New York Community Bank or to Nation Star, which bought assets in the last year and a half or 2 years from the FDIC in various cases. We don't know. And certainly we didn't know then.
That might be more compelling if the facts alleged were that your clients were making their payments were going into some black hole and not being credited to them, and now they're wrongly facing the loss of the security when they've been performing their obligations. But there, as you point out, there are no such allegations in the complaint.
Your Honor.
And I'd inquire as to why.
Well, we didn't allege them because, frankly, we didn't think we had to. I mean, they're arguing
it would be pretty compelling if you could. I've yet to see those allegations in any complaint, and I've been doing these cases now for a while.
Well, there are a lot of allegations you see in the other cases that weren't made in this complaint, Your Honor, because I tried to focus on what we thought was the problem. The problem here was my clients, after the deed of trust sale was set, were sent the note, which had been assigned to somebody other than the party, Premier, in whose name the sale was being held. If they make payments to Premier, the only person they can pay under the note, at least, to cure the default, and under the statute, cure the default, and under the deed of trust to defer the default, assuming that it was a default, then they're paying the wrong person. And you can, in the Sitton case.
But were they paying the wrong person?
Well, we don't know.
We
still don't know.
Okay.
We still don't know. We don't know whether the FDIC owns this.
Were they paying any person?
No, they weren't.
So then
again,
you do know that they weren't paying the wrong person.
Well, Your Honor, you're making arguments to take me beyond the record.
Well, I'm really not making arguments. The whole issue here is materiality, right? Isn't that under Sitten? I'm sorry?
Under 420 and Sitten. Right?
Yeah, under 420 and Sitten. Isn't the touchstone of our discussion today materiality?
Under that statute, Your Honor, the materiality is that a deed of trust sale was being conducted in which there was a right to reinstate by someone who did not own the note and had no right to conduct the sale.
As you began your argument, this is a 33-420 case. So if that's the dispute we have, and materiality is essentially dispositive of whether 12b-6 should be granted, we have to ask material to what? You can't have materiality in the abstract. They're not concepts that can coexist.
Unfortunately, Your Honor, I'm so old I remember when this statute was passed, okay? It was passed largely because you had people going out and filing or recording liens against the property of public officials and other people that had absolutely zero merit and couldn't be material to anything because nobody would take them seriously. And what they said was you could bring an action to clear title, and you could hold people responsible for filing those wrongful or recording those wrongful documents. And that was the purpose of the statute. Now, and quite candidly, Your Honor, Sitten is reading something more into that. It really is. Now, I don't want to argue that Sitten was wrong because I don't think we have to go there. In Sitten, the party conducting the Sitten sale and it wound up with the property, we know because of what happened in the summary judgment and everything, that party was a bank, Deutsche Bank, which actually owned the note. And they completed the sale based on their documents. Okay? And by the way, the falsities were not the forgeries and the robo-signing kind of thing that we're alleging here. They were irregularities. That was a phrase used at the Sitten court, Your Honor. And they were irregularities in how Deutsche Bank went about foreclosing what it owned. That's not what we're talking about here. U.S. Bank didn't go about foreclosing this deed of trust. It didn't. Premier Services Mortgage foreclosed non-judicially in this deed of trust sale. That's not U.S. Bank that was doing it. These are documents that go nowhere, and they should be removed from the record, and they come squarely within 33-420. And then beyond that, Your Honor, you have the second deed of trust. These false documents triggered by the deed of trust, which is attached to the complaint, Your Honor, the second deed of trust, triggered a default in that document. So you said, well, okay, U.S. Bank decides, okay, we're going to we're going to show you that we have the note or somehow or whatnot satisfy you. If the softwares were then to bring a current and stop the sale, which they're entitled to do by statute and by the deed of trust, how can they? They've got a second deed of trust that's delinquent and in default. You've taken away their right to cure, Your Honor. You really have. They have a statutory right and a right in the language of the deed of trust itself to cure. And when this default is triggered by false documents, then they don't have the right.
Isn't it triggered more by the failure to pay?
Well, Your Honor, if you're going to tell me that any time that somebody fails to pay a mortgage, that notwithstanding the consent decree, a bank can knowingly make false statements, knowingly robo-sign, and submits purchased documents to foreclose it in the name of another entity because can't be bothered to get it right, then what can I say? If that's the way it is, it is. But I don't think it should be. I don't think that's what the Patent versus First Federal case said. It said that if somebody's going to have the right to do a non-judicial foreclosure, and again, I was practicing when everybody had to foreclose a mortgage and prove their case, so maybe I had the wrong perspective here. But Patent said to exercise that right under the deed of trust statute, what you had to do was follow the statute strictly. Now, the legislature's eroded it. They've, nits and nats, some things, no longer a mistake in the address and whatnot. but the substance is there. You had to do this through a formal process substituting for the legal process. You had to have sworn statements, and they had to be true. Otherwise, you're throwing out, if anybody can make a false statement anytime because the other person is a bad guy or the other person was in default, Your Honor, I just don't think that's right. And if you're the judge, and obviously, if you have a different opinion, then that's probably the way it is. But it shouldn't be. It really shouldn't. I have 5 minutes left. If I'll either use them if you think I'm going to lose and he doesn't have to talk, or I'll reserve my 5 minutes.
Why don't you reserve your 5 minutes?
Thank you.
Morning, Your Honors. Andrew Jacobs for U.S. Bank, the defendant appellee. Because Your Honor remarked that the whole thing here is materiality, I'll skip over Rule 12G in the law of the case unless Your Honors ask about it. Materiality here is pretty clear and easy to resolve as long as Sitten is the law in this court and in this state. Sitten begins, its first sentence is a very clear statement that you can neither obtain damages nor unwind a trustee's sale when you have immaterial errors. And so...
Would you concede that there are errors here?
There are errors that are immaterial here, Your Honor. I concede.
And why was there never an effort to fix them?
I can't speak to that, Your Honor. As far as the substitution of trustee, the first two errors go to what he called a dead sale, Your Honor, which is, I think, calls into question the materiality of what we're discussing. But I don't think you need to fix errors in a dead sale because the sale isn't going forward. The third one, however, is MERS acting as the nominee, which it has the power to do under the deed of trust, assigning beneficial interest to U.S. Bank. And I think MERS has the power to do that. I don't think that would need to be fixed.
So with regard to the third sale, I know we're on a motion to dismiss, but with regard to the third sale, it would be your position that there are no errors.
With regard to the assignment, the assignment to U.S. Bank by MERS, I would assert that that is itself not requiring correction or erroneous. The prior two, there may have been a predating by 3 days that occurred, and that is exactly the kind of thing that Sitten teaches us as an immaterial error, which we don't allow someone to unwind a sale about. But, of course, there's no sale to unwind, which is why there's nothing material here. When counsel says, well, it's a dead sale, I'm really kind of hard-pressed to understand what the materiality could possibly be. The mortgage not being paid and the sale not occurring.
Well, there's a right to statutory damages, I suppose.
I appreciate that, Your Honor, and when this court construed that statute in Sitten, it said that you cannot get damages when there are merely immaterial errors. So the statutory right to damages, thus construed by this court, means that there is not some sort of uncabined right to damages. You have an implicit requirement of materiality, which is partly expressed in 420, of course.
I'm fairly well familiar with Sitten, but I'm just trying to clarify the record in this case. And so when I ask about these errors, I understand your position is that they're not actionable. I'm just trying to understand where they are. And so your contention, to make sure that we're absolutely clear on the record, is that the only errors are those relating to the first two quote-unquote dead sales.
The three documentary errors we're talking about are the September 17, the September 20, and the September 21 recorded documents. The first is a notice of sale, and that's the sale he said is dead. And at that point, he's saying the trustee of the deed of trust was Stewart Title, and he's saying FA Insurance recorded it anyway, and that's a dead sale, and it can't be material, and they weren't paying, but that's the one we're talking about. So I'll say that was erroneous by 3 days. On September 20, it says FA Servicing executed and recorded a substitution of trustee that substituted FA Insurance for Stewart Title. So FA Insurance on the 17th probably shouldn't be recording something when on September 20 it is substituting as trustee. It probably should have recorded those in the opposite order, Your Honor. That's what I was trying to say.
Okay.
That's about it for errors that I'm going to concede presently.
Thank you.
Thanks, Your Honor. So just a little bit about materiality. I think the one thing I thought might be helpful to discuss with Your Honors this morning is what I think is their attempt to conflate the discussion of standing in Stauffer with the requirement of materiality in Sitten. And they're not the same thing, and those are the relevant moving parts in those two opinions that I think talk to each other and need to talk to each other and help, I think, in resolving this case. when we look at Stauffer, I'll call it Stauffer 1, the prior opinion, in paragraph 25, the one they cite because it has that reference to injury, and I understand why they're citing it. The topic sentence of that paragraph is, we reject the bank's assertion that there is no, quote, jurisprudential standing. So that paragraph is geared to the question the banks raised, and, unsuccessfully in the prior go-round, that their client didn't have standing. And that was probably an artless way for it to have been raised, and that paragraph talked about standing in terms of injury, which is sometimes, but not nearly always, how we talk about standing jurisprudentially. Now, Sitton had a very different way of talking about standing, and I think doctrinally better, clearer, and Sitton was very clear that there was standing even in the absence of a valid claim. And so it disaggregated the two ideas that are kind of mushed together in their recitation of paragraph 25 of Stauffer. Sitton said, well, you're the right kind of individual or litigant to bring such a claim, so you have standing that way. And it said also in Sitton that, these are the kinds of documents that fall within the ambit of 420. So, okay, you have standing that way, but you still don't have a valid claim for want of materiality. And that's the right way to relate those two concepts, and they hadn't yet been unpacked in Stauffer in the opinion. So when they say, well, we have injury and it's the law of the case that there's injury, it's the law of the case that there's standing, which we're not presently disputing. We appreciate they have standing. They're the right kind of person under the statute, the right kind of document. But it is entirely immaterial, as parts of the argument confirmed already, in terms of it being a dead sale, in terms of it being a misrepresentation, if at all, about a particular entity. I mean, who's the trustee doesn't have to do with how you're going to guide your conduct. And that's paragraphs 31 and 33 in Sitton, where the court said, look, material to what? The very question the court just posed. And it defined it in a rather narrow ambit. And it said, materiality to, are you going to pay this? Are you going to seek to renegotiate it, seek forbearance, or be foreclosed? That's the relevant space of your predicted action. Now, there could be, footnote 6 leaves open, there could be the possibility of some other way it could be material. But I think, footnote 6 was talking about, in the abstract, what could happen. It's the requirement of the pleader to articulate a concrete particular circumstance in which there would be a particular reliance interest on something. And they haven't pleaded anything that takes you out of, perhaps some other wrong entity might foreclose. But Sitton's pretty clear that that doesn't get you there. And I think, frankly, Hogan's pretty clear in paragraph 11 that that doesn't get you there, because Hogan says you're protected under the anti-deficiency statute. So for the reasons discussed, without wishing to belabor it, we think there is no materiality, and unless Your Honors wish to hear a bit about Rule 12G or the law of the case, that's all we really have.
The second lien was released?
That's my understanding in the papers, Your Honor.
So that wouldn't pose any injury?
That's my understanding, Your Honor. Although, again, the fact that it's a 5-year-old dead sale, I think, adds comfort to that conclusion. Thank you, Your Honors.
Just briefly, Your Honor, some factual issues. We've alleged forgeries. Hank Dong, supposedly, who offices in Texas. There's a notarization supposedly in California. We have 2 signatures in different places and different documents by a woman. I don't want to go beyond the record, but the signatures are alleged not to have any correlation, okay? But putting all that to one side, and by the way, Your Honor, the clients did request, when they discovered the discrepancy in the note, did say this sale should be renoticed. And the trustee and whoever's giving them directions apparently decided, no, they wouldn't do what they later did, renotice the sale. They went forward with this one. But I want to direct and see if I can focus on what I think is really important here. What is it that has to be material? Is it the allegation of the document being false, or is it materiality under 33-420 when a recorded document has an effect? Now, what you have here is a recorded notice of trustees sale, and the documents relating to it that we believe are forged and not accurate, and all of that's beyond all the other irregularities. but the effect they had on the second deed of trust or any opportunity for someone to do something with their title is there. Once that is done and triggers a notice of default in the second deed of trust, that's a damage under 33-420. Now, as the
That's a damage only if it happens wrongfully.
right, and that's what I'm saying. Then you get down to, were the documents
Let me put it this way. If everything had been done perfectly, exactly according to Hoyle, wouldn't that same damage have occurred?
perhaps not. Perhaps it could have been reinstated and some negotiation could have been worked out.
With whom
With
would your
two.
clients have negotiated?
Well, negotiate with the
You can't negotiate with
servicing
the
agent.
trustee.
Well, you make it current and then negotiate with the second deed of trust.
Bring what current?
If one did what you say, Your Honor, cure the delinquency in payment.
No. The hypothetical I gave you was, let's assume that all of the documents recorded had been beyond reproach, absolutely perfect. Signatures, sequences, everything perfect. What would have been different?
Probably would have been reinstated.
What would have been reinstated?
The first deed of trust.
Why? Was there
Because
a payment tendered?
then it would not have been wrongful, and they could have gone forward and paid, knowing they were paying the right person.
So all the payments were simply withheld because of uncertainty about where the money was going?
Initially, they were withheld, Your Honor, because they were told there were federal programs that would help them, and after months, well, you know all the story, they were told they had to become delinquent before Wells Fargo could, quote, help them. Okay?
I do understand that.
And could they have, when they realized that this was a legitimate sale, could they have brought a current? Could they have then gone to the second deed of trust and worked something out? I don't know. It may have been too
Well,
late.
do you
then.
allege that?
Well, I don't think we have to. We don't have to allege damages.
I just asked you if you
Yeah.
did,
No.
not whether you
No,
have
we
to.
allege that there was a second deed of trust, and the documents were material. I believe that's alleged in there.
Material, okay.
But look, there are two aspects of materiality, Your Honor. I don't want to interrupt, but we're having a dialogue here that's meaningful, okay? The materiality under the statute is the materiality of the recorded document. It sets a sale and it triggers something. That's material. Then there's a materiality under Sitten, and that is, well, did it make, were these false documents, did they cause damages? But that's not the test. Once we have, because in Sitten, it was being foreclosed by Deutsche Bank, which had it. It was theirs. They just didn't do it quite right. Here, U.S. Bank was foreclosing in the name of Premier, somebody who didn't own it. It was manifestly false.
And have you alleged that if that hadn't happened, that if the owner had foreclosed, that anything would have been different?
No, we haven't. Of course not. Any more than they alleged in their first motion to dismiss that it was material. How are we supposed to know 4 years ago we're supposed to allege it when they didn't know enough after motions to dismiss are argued and they lose them in federal court? Then we go into state court and they didn't do it. They go up on appeal. And now, after that, they allege it's material. And how are we supposed to have known in the complaint beforehand? I mean, it doesn't make sense. When we talked a little bit about equity, I heard equity being talked about earlier, Your Honor, in the other case. Doesn't a homeowner being abused by a bank that violates a consent decree and creates false documents, isn't there something about interpreting statutes fairly for them? I leave you with that thought.
All right. Thank you.
You look like you had a question, Your Honor.
No.
Okay.
No, thank you.
All right. Thanks, counsel, to both of you for your arguments. The matter's under advisement. We'll issue a written decision in due course, and we stand adjourned.